Hello and welcome to class number 3 of this UPSC 2024 Prelims Quick Revision Series. A series where we are discussing important current affairs from the last 12 months. I am very happy to see that a lot of you have watched the first and the second class of this series. If you have still not watched that, please use the link in the description of the video. There is a playlist link and you can watch those two classes. Also, to get the PDF of these lectures, join the Telegram channel. The link for Telegram channel again is in the description of the video. In today's class, I'll be taking up topics that were in the news from Indian polity and governance specifically. So without any further ado, let's begin. If you're watching this for the first time, again, I'll remind you this is specifically meant to revise whatever happened in the last 12 months for the prelims exam point of view. So the topics will be on point, exactly what the UPSC may ask without going into a lot of detail. First, topic number 31 is no confidence motion. Number 31 because we have already discussed about 30 topics in the first two classes. As you know, a no confidence motion was moved against the government a few months back, and that is why it has again come in the news. No confidence motion is a motion moved by the opposition parties to indicate that the government may have lost the majority support in the Lok Sabha. If it is passed, the entire government has to resign. Now, please remember a few things. First, the constitution does not mention confidence or the no confidence motion. The procedure for no confidence motion rather is written in rule number 198 of the Lok Sabha. There are some very strict provisions with respect to how no confidence motion can be started. It can only be started in the Lok Sabha. This is where the government must have the majority. It has to get a support of at least 50 members of the parliament, and Rajya Sabha has no role to play in that. As you can see, the Lok Sabha Speaker accepts the no confidence motion. Now, there's an interesting way to look at it. At times, even the government wants that, okay, let the Speaker accept the motion. Because once the no confidence motion is accepted, it allows the government also a lot of time to make speeches in the parliament and put their point across, which is what happened in this case. Now, the opposition parties will first have the opportunity to speak on the motion. Please remember, the opposition parties don't have to tell the reason behind introduction of this motion. There is no reason that has to be given. The Lok Sabha after the debate will vote on the no confidence motion. If it is passed, then the government must resign. There have been many such instances of no confidence motion being introduced in India. As many as 27 no confidence motions have been introduced. The first one being against Nehru government in August 1963, while the last one was in 2018 against the same government in the first term, that is the NDA government when they had the rule from 2014 to 2019. Second topic again in the news, disqualification of the lawmakers. Now, this parliament session saw a lot of disqualifications. They saw a lot of suspensions as well. Disqualification, mainly two that were a lot in the news were of Mahua Moitra and Rahul Gandhi. They were disqualified for different reasons. Now, the article number 102 and 191. These two articles talk about disqualification of member of parliament and the member of legislative assembly on similar grounds. Then we also have a law called the Representation of People Act 1951 that talks about how the members of parliament can be disqualified under various charges. Please do understand, the constitution also talks about how the members of parliament can be disqualified. This is in these two articles. Then there is a separate law also passed by the parliament, Representation of People Act, that also talks about how the members of parliament can be disqualified under section 8 various subsections. Section 8 part 2 says that if anyone is indulging in adulteration of food, drug related offences, indulging in dowry, they will be disqualified. Then section number 8 subsection 4 says lawmaker is disqualified from the period of imprisonment and then up to 6 years. Now, the remaining one is the one that is concerned with Rahul Gandhi. Section 8 subsection 3 says that if a member of the parliament has been given a jail term of 2 years or more than 2 years, then they shall stand disqualified immediately. Again, earlier you used to get time period to file an appeal, but now under Lily Thomas case, the Supreme Court had said if the jail term of 2 years or more is given, you will be disqualified immediately. Disqualification will be for how much time? It will be jail term plus 6 more years. So if you are given a jail of, let's say, 4 years, then you can't fight elections for 10 years. If the jail term is 3 years, then you can't fight elections for 9 years. The jail term has to be 2 or more, and jail term plus 6 more years is your disqualification period. Then you can also be disqualified under anti-defection law, which is a part of schedule number 10 of the Indian Constitution. As you can see, there were many notable disqualifications in the last Lok Sabha, Mahua Moitra, Rahul Gandhi being the ones that were a lot in the news. Talking about the Mahua Moitra disqualification, the next related topic is the Ethics Committee of the Parliament. As you know, Mahua Moitra, Member of Parliament, or ex-Member of Parliament rather, from the TMC party, she was disqualified. There were charges that she had misused her privilege. There were charges that the question that she was asking was in exchange of gifts being taken from an industrialist. Anyways, Ethics Committee came a lot in the news because they were the one who were leading this investigation. Ethics Committee is something you don't really hear about quite a lot. It's not a very old committee. It's a committee that has been formed recently, a few years back. Ethics Committee in the Parliament can be traced back to resolution from 1996. Ethics committees are different in Lok Sabha and the Rajya Sabha. In Lok Sabha, it was first established in the year 2000. It has 15 members nominated by the Speaker who shall have a 1-year term. On the other hand, Rajya Sabha has a separate ethics committee formed in 1997. The Rajya Sabha Ethics Committee has maximum 10 members, and again the term is only of 1 single year. Do remember that. Lok Sabha separate, 15 members, Rajya Sabha separate, that will be 10 members. What do? They look into the ethical and the moral conduct of the members of the Parliament. Whatever case is being referred to them, they investigate those cases for the members. Whatever their investigation is, they will then submit the report to the presiding officer of the House, the Speaker or the Chairperson. In case of Ethics Committee, only an MP can be examined for misconduct. Means they cannot examine anyone from outside the Parliament. Only members of the Parliament can be the one who can look in, or whose activities can be looked into by this particular committee, that is the Ethics Committee. Next news story that was in the news was Rights of Persons with Disabilities Act. Not specifically in one single instance. It was in the news because there were multiple appeals filed in the Supreme Court time and time again throughout the entire year that the application of this act is not being done properly, that the people suffering from disability have not been given their proper rights. That is why the Supreme Court also had asked the central government, what are you doing about it? Supreme Court had said that we do not think that the governments are doing their best in providing the rights to the persons with disability. That is why this act has been a lot in the news. Now, this particular act simply says that the people suffering from different types of disabilities, 21 in total, will be given some preferences. They will be given some facilities by the government, including reservation as well. Please remember, the act earlier had identified only 7 disabilities, then it increased to 21 disabilities. There are 3 categories of people in this. First, people with benchmark disability. Second, person with disability. And third, people with disabilities having high support needs. Some of these 21 include blindness, leprosy cured person, hearing impairment, locomotor disability, intellectual disability, dwarfism, and even mental illness is a part of it. Do remember this. Even mental illness is considered as a part of these 21 disabilities which are recognized under this act. Now, what are the preferences given to people covered under this act? Number 1, the reservation that they have in government jobs has been increased to 4%. It used to be 3% earlier. In higher education institutions, they get reservation of 5%. It was again 3% earlier. Also, the right to education that applies to them is until the age of 18 years. In usual cases, right to education gives you right to free education till 14 years of age, 6 to 14. For persons suffering from disability, they get right to education, that means free school education up till the age of 18 years. So do remember that as well. Also, there is a separate state and national fund to give any support required to people with disability, whatever they require in the long run. Next article, again Another law that was a lot in the news, not a law that has been passed recently, but a law that was in the news, that is the POSH Act. POSH stands for Prevention of Sexual Harassment at Workplace. The reason being, there was a lot of protest by the wrestlers at Jantar Mantar against the chief of the Wrestling Federation. The government responded to it by making a committee. Committee was formed under leadership of the famed boxer Mary Kom. Then the committee came up with its findings. Now, this committee, when it was formed, it mainly looked into the question of whether this act was violated. That is, whether the Prevention of Sexual Harassment at Workplace Act was violated or not. Whenever you read about this, I am sure all of you have read about Vishakha guidelines. This originated from a famous case of Vishakha. Basically, Vishakha is the name of an NGO that had filed a case along with other NGOs for a lady from Rajasthan called Bhavri Devi. She was gang raped at her workplace. There was a case filed on that. Supreme Court got very agitated that the government has not formed any law to prevent sexual harassment at workplace. Supreme Court in this case came up with what you call as a Vishakha guidelines. On the basis of Vishakha guidelines, later on the government of India passed this law. So Vishakha guidelines came first in 1997. The court said that not having such guidelines is a discrimination against women and it's a violation of Article 15. The POSH bill was first introduced in the year 2007 and the parliament finally enacted that in December 2013. So if you can see, even after Vishakha guidelines were introduced in 1997, it took about 16 years for such a law to be introduced in the country. What does this law say? This law defines what sexual harassment will be. Sexual harassment will not just be sexually harassing someone in exact words. Even physical, verbal or even non-verbal conduct, which can include sexual favors, making sexually colored remarks, also will be considered as sexual harassment. So even if you say something which has a sexual inclination that makes the other person feel uncomfortable, even that will be called as sexual harassment. It talks about 5 circumstances that would constitute sexual harassment at workplace, including humiliating treatment that affects health and safety, any threat to detrimental treatment, so on and so forth. It defines who are the employees who will be covered. All the women employees, if they are working regularly or temporarily, or even daily wage workers that come there, interns, will be covered under this. The important part is all women employees are covered, means it does not cover men. So if there is a male employee who is facing sexual harassment at workplace, he cannot take refuge under this act. Do remember this. The POSH Act is specifically for women employees, either permanent employees or daily wage or interns, whoever visits that place, but only they are covered. Also, it expands the definition of workplace. Workplace will be even non-traditional workplaces will be included here. Telecommunicating means let's say you're working from home, even then it will be covered. You can't say that, oh, this lady does not even come to office. Even if she's working from home, online, on the laptop, on computer, even then she will be covered. It includes, or the act applies to all public and private establishments in India, entertainment industry, education industry, all of these are included in this act. Now, how does it work? Basically, what is the mechanism to investigate the case? There is something called the ICC, Internal Complaint Committee. So the law says every organization having at least 10 employees, this is the benchmark, at least 10 employees, will have to make a committee called the Internal Complaints Committee. This is the committee where complaints can be filed by a woman. They will have powers similar to a civil court. They can summon the person, they can examine the person, and then they can decide on this matter. This committee will have minimum of 4 members and at least half should be women. Also, leader of the committee, head of the committee has to be a woman employed at a senior level in the organization. Now the question is, what if an organization has 9 members? What if an organization has only 8 employees? Then what happens? they cannot or they might not have internal complaints committee. For them, there is a provision of this local committee. So internal complaint committee for those that have at least 10 employees. Less than that, if they don't want to form this committee, then there will be local committee that will be in charge. Local committee basically will be the committees at the local level, means outside that organization. It will be at the level of the government, the local employees of the government, they will be the one who are in charge. So local committees will be formed that will receive complaints from those organizations with less than 10 members work, or even domestic workers can come and complain here. Also in the internal complaints committee, they have to have at least 2 members who have experience in social work. These committees should also have an external member who is working from an NGO, so that the committee can work without any interference from the high level position. The Ministry of Women and Child Development also runs a platform called the She Box. This is an online platform on which you can file complaints and they will be transferred to the internal complaints committee of that particular organization. So again, these are the provisions for the POSH Act. Next, another law in the news, Forest Rights Act. Forest Rights Act is one of those laws that remain in the news for a lot of reasons. There are multiple cases filed in the courts arguing that forest rights have not been given to people who are living in the forest, that there is deforestation, etc. Let me first explain to you what exactly is the Forest Rights Act. So there are people, tribal people usually, who have been living in forest for a very, very long time, from many generations. The problem is they don't have official paperwork to prove that where they are living, the land belongs to them. So if they don't have official paperwork, the problem is they can be displaced easily. Some corporate comes in, removes them, and then takes over their land because they don't have ownership to prove. So the government started this Forest Rights Act, under which the idea was, if your family has been living in the forest for a very long time, that area, maximum 4 hectares, government will officially make you the owner of it. You will be given paperwork that this is your land, so that next time someone comes, they can't just overthrow you. You have the right to use that land. That is the idea of the Forest Rights Act. That is giving the ownership rights to people who have been living in the forest for a long time. It is called the Forest Dwelling Scheduled Tribe and Other Traditional Dwellers Act, who have been residing in forest for many, many, many generations. Who runs this act, or who is responsible for its implementation? Ministry of Tribal Affairs. Now, in these kind of laws, the problem is, how do you identify when someone says my family is living here for a long time? Maybe they just came in few months ago when the law was passed and they thought it is a good way to take up the land. So government has to verify their claims. So the question is, how does the government verify the claims? This is where the role of the Gram Sabha comes into the picture. What Gram Sabha does is, they will have to verify the claims. Gram Sabha, as you know, is the assembly of all the voters in the village. They verify the claims whether the person and their family is lying or whether they are telling the truth. After the claim has been verified, maximum of 4 hectares, again maximum, it's not that 4 hectares will be given depending on how much area they use, but maximum 4 hectares will be given, ownership of land will be given, and no new land will be granted. Only that land where you are living and where you are basically, which you are using for your own cultivation, that will be given, not more than that. You can also use minor forest produce, and you can use this area for grazing of your animals. The government also decided to rehabilitate in case of illegal eviction. So in case you are illegally evicted, you don't have basic amenities, you will be taken to other place where the government will rehabilitate you. Also, you have the right to conserve your forest, because most of the people from the tribal community have very high regard for the forest. Forests play an important role in their life, even for religious purposes. So the government recognizes this, recognizes their right to conserve the forest as well. The next law that was in the news, because it was amended a few months back, this is the Registration of Birth and Death Amendment Act of 2023. Now what exactly is this? Basically, any birth or death that takes place in India, all that is obviously registered. Now the problem here is, right now it is registered at the state level. So every state has its own registry of deaths and births that take place. Then the problem is that it is not really compiled properly at the national level. So the numbers may have a mismatch. It came in the news when, remember when there was COVID-19 crisis and there was a question asked to the government, how many people died in COVID-19 crisis? A statement came from the government that no one died because of lack of oxygen. Central government blamed the state that they did not give us proper numbers. So there was a need felt to rectify this mismatch of deaths and births from the state level to the central level. And that is why the act was amended. Now this act gives the power to Registrar General of India to manage National Birth and Death Registry. We have chief registrars at the state level. We have registrars at the local level also. They will contribute, or they will basically look into the data, but they will then have to submit all the data at the national level to Registrar General of India. The Act also talks about digital registration and electronic delivery of birth certificate and death certificates rather than doing it by hand. I still remember my birth certificate was just a piece of paper given by the municipality. So it was again on paper, very difficult to preserve. Now it is all to be done electronically. The Act also says that births and deaths have to be communicated to the registrar. For example, medical officer in charge of the hospital where the birth takes place, they must report this birth as soon as possible to the registrar. So there have been specific responsibilities that have been fixed, that you have to report the birth or the death in hospital to the registrars specifically. All the state governments have been mandated to share the data with the Registrar General. The database again will be linked to government schemes as well. Because see, one of the other problems that we have with data not being updated, the birth and death data, is the government schemes that aim to reach all the people, be it, let's assume the government scheme of Ayushman Bharat, pensions from the government, other kind of schemes of free ration, all of that require exact detail about how many people are there in some families, how many people live in which cities, etc. The government in fact allocates budget depending upon the population of a certain place. So it really is necessary to have the exact data in terms of birth and death as well. Penalties will be imposed if the registrars fail to register death and birth as per this law. Real-time data of both death and birth will have to be shared on public domain by all the state governments, with the central government now moving forward. This Registrar General can share the database with different government agencies along with population numbers, Aadhaar numbers, etc., so that the government schemes can be formed in a manner that impacts the maximum population. The Act requires birth and the death certificates of the people to prove that they have died or they have basically taken birth. Information will be used for different purposes. This birth certificate can be used for admission to education institution, for voter list, etc., for applying for government jobs as well. Do remember, this Registrar General of India works under Ministry of Home Affairs. Now again, I said in the beginning, I'll repeat this once again. The purpose for this series is to give you to the point information to help you revise, because we don't have a lot of time left. So we are not going into a lot of details that may be important for the mains exam. We are specifically focusing on those details that have a probability of being asked in the prelims examination. So take that this series in that manner. Next important news, suspension of the members of parliament. We had an unprecedented situation in which 141 opposition members of parliament were suspended. Now, suspension of members of parliament is not something new, but suspending them in such large numbers is something that is not seen very usually. This is why it is a lot in the news. So there are general rules about how and when a member of parliament can be suspended. The rule is presiding officers can direct the members of parliament to withdraw from the house for disorderly conduct. Also, if that does not work, if the member of the parliament still remains in the house, does not go out of the house, then the presiding officer can name the legislator and the House can move a motion to suspend the member of the parliament until the end of the session. So first is usually a kind of a warning by the presiding officer saying that you should go out, you should not stay here. If the member of parliament does not attend that or does not abide by that, then the naming of the legislator can be done and the motion can be passed against the legislator to suspend him or her until the end of the session. There is something also called the automatic suspension. This is something that started in 2001. Please understand this. In 2001, what Lok Sabha did was, a new rule was introduced. MP named by the speaker shall automatically be suspended for 5 days or remaining part of the session without the need for the House to pass any motion for suspension. This is interesting. Do note that this rule does not apply to Rajya Sabha, it only applies to Lok Sabha. Means in Lok Sabha, just the naming of the member of parliament is enough by the speaker and the member of parliament will be suspended. In Rajya Sabha, if the member of parliament has to be suspended, it has to be with the passing of a motion. Please do remember this detail. It is important. Most of the rules for Lok Sabha, Rajya Sabha are the same, but there are a few handful of rules that are not the same, and this is one of those, where in Lok Sabha, member of parliament can be suspended just by the speaker naming without the need to pass a motion. But in Rajya Sabha, a motion has to be passed necessarily. Also, there is a difference between expulsion and disqualification. For example, a member of parliament that has been expelled can contest the elections again and can come to the parliament after winning the elections. But if they have been disqualified, then they can't fight elections for a specific time period. For example, we just discussed, if member of parliament is given 2 years or more of jail term, then they are disqualified for 2 plus 6 years. Expelled members can contest the elections once again as soon as possible. They can come back, but disqualified members cannot come back for a certain time period. Next topic is a phrase that was used by the Chief Justice of India, something called forum shopping. The Chief Justice of India spoke against the concept of forum shopping. That is why you should know about it. What exactly is this? The simple idea is, when you specifically, knowingly transfer or try to take your case to a specific judge, hoping that this judge or this particular court will be in your favor, this is called forum shopping. When you try to choose which judge should hear your case, when you try to choose which platform should hear your case, that is called forum shopping. This is not allowed, obviously. As you know, the master of the roster in the Supreme Court is the Chief Justice of India. He decides which judge will hear which case. Forum shopping, as I said, is when litigants try to move their case to a particular judge or a particular favor. There is domestic aspect of this, where within India you try to transfer your case to a specific judge who may be favorable to you. There are transnational aspects also, where you try to move your case from one court to the other. For example, let's say when the Italian Marines were being charged in India because there were 2 Italian Marines who had shot down fishermen in India. When their case was going on in India, Italy was of the view that this case should not be heard in India. It should be heard somewhere else at the international forum. It should be heard in Italy, because they wanted a forum where they thought that their case will be heard favorably. So when you go to a forum hoping that your case will be heard favorably there, that is called forum shopping. Globally, in US and UK also, this practice has been criticized. You can't have a proper law against it because it is not something which is on record. It's an informal practice, but yes, it has been criticized time and time again. The last news from this section of Indian Polity today's class is National Judicial Data Grid and portal, where the Supreme Court also has now joined it. As you all know, National Judicial Data Grid is an online portal where you can find real time how many cases are pending, how many civil cases, how many criminal cases are pending in India. Now, till some time ago, Supreme Court was not a part of it. Till some time ago, you could go to this portal, you could look into the cases pending in high courts, district courts, etc., but not the Supreme Court. But now even Supreme Court has joined this, which is again important. Supreme Court will have a specific portal. There will be a link in this portal where you can actually click and go redirected to the Supreme Court specific portal. It will be National Judicial Data Grid, Supreme Court of India. It will give you the following data: pending cases, both criminal and civil, how many cases are filed and disposed in the last month, and the number of cases pending before 3 judge, 5 judge, and even 9 judge benches. Who has developed this portal? It has been developed by NIC, the National Informatics Center, and the computer cell of the Supreme Court Registry. The NIC specifically, as you know, many government websites have a .nic domain name. So NIC is something that came up in 1976 under Ministry of Electronics and Information Technology. This is the one that handles most of the government websites and looks into government development. So next time you don't like a design of a government website, you know who to blame. What exactly is this portal? It's a national data repository that came up in 2015 specifically. Again, it started with courts at the district level, then there were high courts, etc., whose data came up, and now even Supreme Court's data has come up in this portal, and it gets on updated real time. Now it is also being said that e-courts will also be a part of this. The government is now trying to see if there are online cases that can be heard with the help of this particular portal going forward. This was the class number 3 of the quick revision series. Please do watch all the other classes coming up. If you're still not subscribed to my channel, please do that right away. Invite other aspirants as well. I'll be back with lot more topics. There are still Indian polity topics remaining. Be back at 6 p.m. tomorrow. If you want the PDF of this lecture, join the Telegram channel. The link is in the description of the video. Thank you so much. Bye-bye. Jai Hind.